Hey everybody, this is Tracy here with another edition of A View from Tracy's Point. And before we get started in this particular video, or I tell you what this video is about, I want you guys to know that I have two videos that I need to bring to you all. So I posted a video yesterday, I believe it was, where I talked about Jennifer Bonjean and the Eastern District of New York both responding to the two questions that Judge Donnelly had. And so that was actually supposed to be my second of three videos, but YouTube flagged my first video, which was on the Chicago case. And so I need to go through that video and edit it to see, and I guess edit out what I think it is that YouTube flagged it for. And so I may have told you or may have not told you, but I have a new grandbaby. And for some reason, he thinks I'm supposed to just sit and hold him all day. So it is making it very difficult to get these videos done. And then the third video, I was halfway through with that video, and it is about the Minnesota civil suit. And so I need to finish that up and get that to you. But then today, Jennifer Bonjean dropped her memorandum on Mr. Kelly's sentencing in the Eastern District of New York. So I am going to go ahead while he's taking a nap and try to get this video done. He's already interrupted me once, and then I had to go run some errands, and so it's getting hard out there here in these streets, all right, to get these videos to you all. So let's go ahead. Defendant Kelly's sentencing memorandum, part 1. It says, introduction. Defendant files a preliminary sentencing memorandum in support of his contention that the guidelines range for his conviction is 168 to 210 months. Defendant further contends that upon consideration of the factors set forth in Title 18 United States Code Section 3553A, this court should sentence defendant to a below guideline sentence. Consistent with the court's order, defendant intends to submit supplemental sentencing memorandum on June 13, 2022 that addresses the Section 3553A factors with supporting mitigation that sheds light on the history and characteristics of the defendant. So the argument, it says a district court, and before I get into the argument, a lot of the information that I am going to read in this document has already been shared in the sentencing report from the probation office that I've already did a video on, and I will try to remember to drop that above so you guys can check that out. And so the argument is a district court should begin all sentencing proceedings by correctly calculating the applicable guidelines or applicable guidelines range, which should be the starting point and the initial benchmark. And that comes from Gold versus United States, which was a case heard in 2007. After a proper calculation, a sentencing judge considers the 7 factors set forth in Title 18 United States Code Section 3553A. And then there's a quote, the nature and circumstances of the offense and the history and characteristics of the defendant, end quote. The 4 legitimate purposes of sentencing is set forth below, and there's another quote from Section 3553. The kinds of sentences available, the applicable guidelines range itself, and relevant policy statement by the Sentencing Commission. And then, quote, the need to avoid unwarranted sentence disparities among defendants, end quote. And a new quote, the need to provide restitution to any victims. And once again, this is from Title 18, United States Code, Section 3553, A1 through 7. And then she's referencing this case that was Gall versus United States. And I'm trying to be better about telling you guys what are quotes, because I think a lot of times the information gets misconstrued and you don't understand or can't separate from the video what was coming from another case and what the attorney is saying about this case. And so I'm trying to be better about separating when Jennifer Bonjean is actually talking and when she's quoting from these previous rulings in other cases. So in determining the appropriate sentence, the statute directs judges to, quote, impose a sentence sufficient but not greater than necessary to comply with the purposes, end quote, of sentencing, which are A, to reflect the seriousness of the offense, to promote respect for the law, and to provide just punishment for the offense. B, to afford adequate deference to criminal conduct. C, to protect the public from further crimes of the defendant. And D, to provide the defendant with needed educational or vocational training, medical care, or other correctional treatment in the most effective manner. And then once again, this is coming from section 3553A2. So the guideline sentence in this case is 168 to 210 months. The government and probation argue that the defendant's guidelines range is life, although they take different routes to arriving at that conclusion. As set forth in detail below, many of the enhancements suggested by the government and probation are simply unsupported by the evidence and the law. Defendant argues that the range is 168 to 210 months. Okay. Oh, so there's Jennifer Bonjean is saying that the range should be 168 to 210, and the government is saying life. And let me pull out my little calculator here and see what okay, that's set. So 14 to 17 and a half years. Miss Jennifer, I think that's a little bit too much. I think 3 years is all he deserves, because, and let this man go home for this foolishness, but definitely not no 14. So 14 to 17 years would end up being 11 to what? 14 years? 11 to 14 years? That's too much time. No, ma'am. Too much. Probation sets forth a comprehensive summary of the charges, convictions, and evidence presented in this case. Defendant has already lodged objections in response to the pre-sentence investigation report, including objections to some of probation's statements about the government's evidence. Defendant will highlight the trial record in this case as necessary below. Defendant was convicted one count of RICO based on conduct alleged to have occurred between 1994 and 2018. The base offense level of a racketeering offense is the greater of 19 or the offense level applicable to the underlying racketeering activity. I think it's United States Sentencing Guidelines, Section 2E.1. Application note of the commentary guideline 2E1.1 instructs that, quote, where there is more than one underlying offense, that underlying offense as if contained in a separate count or conviction for the purpose of subsection A2, end quote, defendant calculates the offense levels for each racketeering act as follows. So, hold on a second. A, Racketeering Act 1, bribery, base offense level 12, adjusted offense level 12. The government and probation contend that a 2-level enhancement is justified on the basis that defendant used a person less than age to commit the offense. As argued in defendant's Rule 29 motion, the government's evidence failed to show that defendant knew that Demetrius Smith paid money to influence a public aid officer to produce an identification card for Aaliyah. The record is also devoid of any evidence that defendant used Aaliyah in connection with the bribery. Of course, the bribery committed by Smith produced a fraudulent public aid card for Aaliyah, but it does not follow that defendant used Aaliyah in the bribery. Accordingly, defendant objects to a 2-level enhancement pursuant to the United States Sentencing Guidelines, Section 3B1A. And can I stop right here, because I was thinking about this. I did a post on Twitter a couple of weeks ago where I talked about the fact that nobody that was involved with this alleged bribery other than Demetrius Smith was called to the stand to testify. We didn't have the public aid person who, depending on her age at the time, might be deceased and gone on to glory, but we didn't even learn what her name was. She didn't testify. We didn't learn why she didn't testify. Then we move over to the FedEx office, the courier service, which I think turned out to be FedEx. We never found out who that person was that allegedly gave the fake ID, the work ID. Never got a name for that person. That person wasn't brought into trial. We didn't see the fake ID for the employment record at FedEx, and we didn't see the fake public aid ID. They didn't show any of that at the trial. Then we moved to the person at the Maywood office who accepted the documents. We don't know who that person was. We didn't get that person's name. They didn't come in and testify as to why they accepted a document that was not on the list of documents that are approved to get a marriage license. Like, none of that came out during trial. Nobody in that Maywood office came in that was at the Maywood office during the time that this alleged scheme took place, which was 1993, I think, or 94. None of them came in and testified about this. So it seems to me that if the person accepted a document that was not on the list of legal documents to get a marriage license, then there was no marriage license. The marriage license is null and void. Then we move on to the fact that the clerk who came in, the current clerk who came in to tell what the policies and procedures were, she stated that they came in, I believe, on the 30th, which would have been when they flew in from Macon, Georgia. So they flew in overnight. They went to the public aid office. They went to the FedEx office. They went and got the marriage license, and all of this all in the span of one day. And then they went to the hotel where this Nathan Edmonds guy performed the ceremony. All of this took place on the 30th. The Edmonds guy said that he gave, I guess, Barry Hankerson, who was there, the marriage license. That he was not the one that turned the license in or anything, right? So it was clearly stated during the testimony that the license is issued and you have to wait 24 hours before you actually perform the marriage ceremony. So when these documents were turned in, mailed in, they weren't hand delivered, they were mailed in. When they were mailed in, the documents mysteriously stated that it was August 31st that this marriage took place, when according to the evidence, the marriage took place on the 30th. Everything took place on the 30th. So that is the second reason why there was no marriage, and the marriage is null and void. And then there was allegedly an annulment that took place a few months later, and we didn't get any documents about this annulment. I don't even know if the annulment was ever mentioned when they were on this part of the trial. And so I had to go back and read those transcripts to see if I was missing something, because none of this came up as things that they were going to argue in the motion, right? because I think it definitely falls under ineffective counsel that the defense didn't dig into all of this. But then on the flip side, it got me to thinking, did he tell Jennifer Bonjean that this fake thing actually happened, and what was the story that he gave her as to what really happened, and whether or not she felt that it was worth arguing about? So we go on and continue with B, and it says the government and probation argue that a 2-level enhancement is appropriate pursuant to the United States Sentencing Guidelines, Section 2G2 B2A, on the grounds, sorry about that, had to go close the door. Okay, on the grounds that, quote, offense involved the commission of an act, end quote. Defendant was found guilty of exploitation based on Stephanie's testimony that defendant recorded an act with her when she was in violation of Title 18 United States Code, Section 2251A. The government contends that because explicit conduct and elements of 2251A violations does not necessarily involve an act, defendant is subject to a 2-level enhancement pursuant to the guidelines at Section 2G2.1B2A. Because he engaged in an act with Stephanie, the defendant disagrees. Enhancing defendant's sentencing based on facts that form the basis of the offense amounts to impermissible double counting. Impermissible double counting occurs when one part of the guidelines is applied to increase the defendant's sentence to reflect the kind of harm that has already been fully accounted for by another part of the guidelines, end quote. So she quotes that from United States versus Watkins, which was heard in the Second Circuit in 2012. So the only conduct proven by the government that qualified as explicit conduct was the act itself. Even if the government could have theoretically proved exploitation without evidence of acts, it does not follow that the government can enhance the penalty based on conduct that was already accounted for in the base offense level. Accordingly, a 2-level enhancement is unwarranted. And then C, racketeering acts 3 and 4, kidnapping and Mann Act violation for Sonia. Defendant was acquitted of racketeering acts 3 and 4 related to Jane Doe number 3. The government contends that because it could prove these racketeering acts by the lower preponderance of the evidence, they could be taken into consideration pursuant to United States versus Ruggiero, which was heard in the Second Circuit in 1996. Defendant contends that where the jury clearly found that Sonia's testimony was not credible, this court should not consider racketeering acts 3 and 4 in calculating the guidelines range. Despite the government's contention, it does not ask the court to consider these acts in calculating the guideline range. So D, racketeering act 5, the Mann Act violation involving Geronda. Base level offense 24, adjusted offense level 24. The government urges a 2-point enhancement pursuant to Section 2G1.3B2 because the offense involved undue influence toward the minor to engage in prohibited conduct. Undue influence is defined in the guidelines as activity that compromises the voluntariness of the person's behavior, referring to Geronda. And then it says that the defining characteristics of undue influence is that it involves a situation where the influencer has succeeded in altering the behavior of the target. United States versus Patterson, which was heard in the Seventh Circuit in 2009. The government contends that a rebuttal presumption of undue influence exists because defendant was greater than... Okay. I don't know what she's saying here, but I think a comma or a period should have been in there somewhere. But basically, 16, Geronda, when they engaged in activity between May 29th and January 2010. So once again, it seems that he's conceding that there was something between him and Geronda, which is just creepy as all get out to me, because whew, I will keep my thoughts to myself. So contrary to the government's contention, defendant rebuts the presumption of quote unquote undue influence. The trial record refutes any suggestion that defendant did anything in altering the behavior of the heifer. Quite the opposite. Geronda, a sophisticated teen, took great pains to get close to the defendant, including by misrepresenting her age. Defendant did nothing to seek her out. In contrast, she forged a relationship with the defendant's orbit, within people in the defendant's orbit, falsely claiming to be 19, all to get access to the defendant. She admits that she falsely told defendant she was 19 when they engaged in conduct. It is true that Geronda claims that she promptly confessed to the defendant immediately after their first encounter. However, even if this is true, her testimony does not reveal that the defendant used any influence, undue or otherwise, to engage in activity with her. Defendant has been sufficiently punished for this offense, and a 2-level enhancement for undue influence is simply not justified on the facts of the case. Similarly, a 2-point enhancement is entirely unjustified pursuant to Section 2G3.1b3, where the record is devoid of evidence that the offense involved the use of a computer or cell phone to induce the travel of this person. The government points this court to phone logs, random photos, and a single text allegedly from the defendant stating, "Please call," as evidence of use of a cell phone to induce travel. The evidence fails to show the defendant induced her to travel to her home. The record shows that Geronda traveled to defendant's home with no invitation and at her own volition. Indeed, the evidence showed that Geronda snuck into defendant's home when defendant was not in town. Defendant did not induce Geronda to travel to his house. Furthermore, no record exists to establish the nature of any communications. Indeed, Geronda's testimony does not support the government's argument that she was ever induced to travel to his house by cell phone communication or any manner. An invitation does not equal inducement. The Second Circuit has made clear that the terms persuade, induce, entice, and coerce are words of common usage that have plain, ordinary meanings. United States versus Wakar, which was heard in the Second Circuit in 2001. United States versus Gagliardi, which was heard by the Second Circuit in 2007. I'm sorry, that other case was 2021, not 2001. The court distinguishes this conduct from merely asking, which is not sufficient to demonstrate criminally. And then they have an example here. It says, recognizing that there might be some uncertainty as to the precise demarcation between persuading, which is criminalized, and asking, which is not. The government's evidence fails to show any specific words of persuasion that defendant used in connection with Geronda. Thus, even if the government could argue that defendant asked or invited her to come to his home and told her that someone would pick her up at the train station, that conduct is not inducement. Thus, a 2-level enhancement is not supported by this record. Last, a 2-point enhancement is unwarranted pursuant to Section 2G3.1b4. The government continues to argue that because a violation of Title 18, Section 2422 does not necessitate illegal activity, an enhancement for contact does not amount to duplicative punishment. The government's argue is flawed where Racketeering Act 5 is is premised on a criminal act, namely aggravated criminal abuse under the Illinois Criminal Code. In short, to prove Racketeering Act 5 as charged, the government was required to prove an act. Thus, any enhancement based on an act is duplicative to the charged offense, and the enhancement amounts to double counting. And so, two things here. There's a lot to read, and I'm trying to read it fast before the grandbaby wakes up. And the second thing is, those of you who have been following me for a while know when I'm talking about these acts and conduct that I'm leaving certain words out of the conversation. So E, Racketeering Act 6, forced labor geranda, base offense level 30, and then they have a 2-point enhancement, so the adjusted level offense is 32. As the government pointed out, probation's calculation of the adjusted offense level for this count is erroneous, where the count did not include the production of CP. Although defendant agrees with the government that the base offense level is 30, he objects to the 4-level enhancement pursuant to section 2431B1 because the government's evidence did not establish under any standard of proof that the forced labor count involves conduct described in Title 18, Section 2241A or B. And then I want to point out here, in case you guys are thinking I forgot to do a video on the government's response to the sentencing report, remember they filed their response under seal. So I didn't get to see the response because it's a sealed document. So he continues on to say, as argued extensively in defendant's Rule 29 motion, Geronda's testimony described an assault unrelated to any conduct. Geronda testified that defendant slapped and choked her because she was on her phone, and he didn't believe she was texting a friend. Geronda testified that after the assault, she gave defendant oral because he instructed her to do so. Geronda's testimony is devoid of any mention of threats of violence or acts of force in connection with the act. The previously described physical assault was completed and unrelated to his instruction that she give him blank. Geronda did not even testify that she feared defendant when he asked for oral, and she complied. Thus, the government's claim that defendant placed Geronda in fear of death of serious bodily injury is meritless. Accordingly, a 4-level enhancement is unjustified on this record. F. Racketeering Act 7, exploitation, Geronda, base offense level 32, adjusted offense level 32. The government agrees that there is no evidence that defendant used force in connection with the production of any CP and that a 4-level enhancement is inappropriate. Defendant objects to a 2-point enhancement pursuant to the guidelines at section 2G3.1B3, where the record is devoid of evidence that the offense involved the use of a computer or cell phone to induce Geronda's travel. G. Racketeering Act 8, Mann Act violation, Ariel. Base offense level, section 2G1.1A2, 14, adjusted offense level 14. The government concedes that Ariel misrepresented her age to defendant when she met him in Florida in April of 2015, which kicked off a lengthy relationship. Incredibly, the government seeks a 4-level enhancement on this count, arguing that defendant committed a fraud in connection with this Mann Act violation because he did not disclose to Ariel that he had genital herpes. The government seeks to stretch the guidelines beyond all recognition, which explains its failure to offer any support for its novel theory that the failure to disclose a herpes diagnosis amounts to fraud either as defined by federal fraud statutes, state statutes, or under common law. According to the Second Circuit, fraud involves a false representation, scienter, reliance, and harm, and that was a case that Evans versus Atimo, which was heard in the Second Circuit in 2006, United States versus Fusion Connect Incorporated, which was heard in the Southern District of New York in 2021, citing the restatement second of torts. While there have been a few variations on these elements, harm is always present. And she says to see Page versus Carroza, which was heard in the Eastern District of New York in 1994, breaking scienter up into reasonably calculated to deceive and intended to deceive. So then she goes on to say the government's evidence does not show that defendant falsely represented anything to Azriel or that Azriel relied on any misrepresentations. Also absent is any evidence of harm because there is no evidence that Azriel was infected with herpes when she traveled to California with defendant April 28, 2015 and May 1st, 2015. The government cannot show that any harm resulted from his failure to disclose his herpes diagnosis. Indeed, Azriel testified that she did not contract herpes from defendant during that trip. Thus, the government's fraud theory is patently ridiculous. A 4-level enhancement must be rejected under this theory. And I agree with you. We don't even know if Azriel has herpes. Okay, I don't remember them producing no medical documentation that that child has herpes or is taking any herpes medication, other than her claiming that the doctor was bringing the medication and they were using the medication, which is a good point, that if this man was coming to the apartment and giving all these women herpes medication, wouldn't his license be in jeopardy? Because I don't think that's legal to be just writing prescriptions to people that you have a medically diagnosed with anything. But anyway, they let that slide. That's kind of stuff they'll slide. I guess that's how they got him to get up there and testify, was they promised not to prosecute him or to charge him with malpractice and have his license taken away from him if he came in and said whatever he said. But I would think that the medical board would have been listening and paying attention and would still call him to the carpet, just like in Chicago when the Ed Jensen guy did that article with the Sun or the Sun Times about Mr. Kelly being guilty in the 2008 case. The licensing board, the lawyers licensing board, I can't think of the name of it, but they immediately opened an investigation as to why he was breaking client attorney confidentiality. So I don't understand why the medical board ain't called in the doc and asked him exactly what were you doing practicing medicine in people apartments and condos and all this stuff and prescribing medication to people that were not your patient. But anyway, let's move on. Racketeering Act 9, Mann Act violation, Azriel, base offense level. Is this the one I just read or is this one different? Oh, this is a different one. Base level 24, adjusted offense level 24. The government alleges that the base offense level of Racketeering Act 9 is 32 pursuant to section 2G 2.1, which involves exploitation, and then quote, by production of explicit visual or printed material, end quote. Racketeering Act 9 was a Mann Act violation, and therefore the appropriate guidelines can be found at the United States Sentencing Guidelines section 2G 1.3 C1. Pursuant to section 2G 1.3 3C1 instead of the section that they were trying to use. The base offense level is 28, where the jury determined the defendant was guilty of violating section 2422B. The government seeks to convert this offense into an offense for exploitation, arguing that the base offense level is 32. So they're trying to add a whole bunch of points. But the government fails to explain why this court should not look to 2G1.3C1 as the starting point for correctly calculating the base offense level as to Racketeering Act 9, where defendant was not convicted of exploitation but rather a Mann Act violation. Notably, defendant was separately charged and convicted of exploitation in connection with video recording with Ariel during their trip to California. So confusing. Okay, the government's theory fails for other reasons. At the time defendant purportedly committed Racketeering Act 9, Ariel was living with the defendant and engaged in a legally consensual relationship in the state of Illinois. This is undisputed no matter how distasteful the government finds it. There is nothing in the record that suggests that defendant brought Ariel to California for the purpose of producing a visual depiction of their activity. Notably, the government previously argued that defendant's purpose in bringing Ariel to California was to expose her to herpes. So they need to make up their mind which one was it. The government seems to believe that defendant's purpose in bringing Ariel to California is whatever they say it is, depending on what elements it needs to prove. And I agree with you, Bonjean, on that one. As defendant argued in his Rule 29 motion, defendant's motivating purpose in bringing Ariel to California was to have her companionship, even if included contact. While Ariel testified that her relationship with the defendant involved sex, that intimate relationship was legal in the state of Illinois. It is entirely illogical to suggest, as the government does, that defendant had a purpose in bringing Ariel to California to have sex with her, where they shared a home in the state of Illinois, where the age of consent is what it was and the age that she was at the time. Even if the government persuasively argued that defendant's purpose in bringing Ariel to California was to have sex with her, it cannot be said that defendant's motivating purpose or any purpose was to produce video of that activity. The government knows very well that defendant's travel with Ariel had absolutely nothing to do with producing commercial CP. Any attempt to increase the offense level under this theory is legally wrong. The government agrees that an enhancement pursuant to Section 2G2.1 B6BI is inappropriate. Accordingly, the adjusted offense level for Racketeering Act 9 is 24. Then she moves on to Racketeering Act 10, Mann Act violation, Ariel again. Base offense level is 32. Adjusted offense level is 32. Defendant objects to a 2-point enhancement pursuant to Section 2G2.1B2A on the grounds that the offense involved the commission of an act. Defendant was found guilty of exploitation in violation of Title 18 Code Section 2251A, based solely on Ariel's testimony that defendant recorded their activity in late 2015 when she was not 18. Notably, the activity that occurred in the Northern District of Illinois was legal conduct, even if the recording of it was not. The government's evidence turned entirely to Ariel's testimony, as the government produced no video of defendant and Ariel engaging in that activity during this time period. But there's folks out there that be arguing with me, y'all. There was some video. You don't know. It wouldn't show in the transcript. Well, no, the video wouldn't show in the transcript. However, there would have been an indication in the transcript that at this moment an exhibit is being shown. And then at the end of the transcript, it lists what all the exhibits were. And that did not occur. And so here we have clarification yet again. Yet again. Okay. So first, the government should not be permitted to enhance the sentence guideline for this offense based on contact that occurred in the Northern District of Illinois, since that contact was not unlawful. The unlawful activity in the Northern District of Illinois was the filming of the contact, not the contact itself. Therefore, this enhancement could only be applicable for any contact in the state of California. But again, as argued supra, because the contact that occurred in California arguably forms the basis of the charged offense, it would be duplicative to enhance this offense based on said contact. Contrary to the government's argument, simply because explicit conduct does not require proof of an act for purposes of demonstrating Section 2251 violation, where the government's proof of explicit conduct is the act itself and nothing more, the government cannot enhance based entirely on theoretical. Here, the element of explicit conduct was allegedly proven by Azriel's testimony that defendant produced a, and then she has a note at the bottom that says the jury was not asked to determine whether Racketeering Act 10 was based on conduct in California or Chicago or both. Okay, so they were playing word games. So it says was allegedly that the explicit conduct was allegedly proven by Azriel's testimony that the conduct formed the basis of the charged offense and should not also serve as a basis to enhance defendant's sentencing, notwithstanding that the government did not need to prove the act established a Section 2251 violation. Such an enhancement would constitute impermissible double punishment under the facts of the case. The government agrees that defendant's offense level should not be enhanced by 4 levels pursuant to the United States Sentencing Guidelines Section 2G2.1B4. The government urges a 2-level enhancement pursuant to Section 2G2.1B6. Arguing that defendant stayed in touch with Azriel by cell phone in order to induce her to travel to see him. Defendant and Azriel were in a relationship. They lived together and they traveled together. Defendant did not use a cell phone for any purpose other than communicating with his girlfriend. The government and the public may be outraged that defendant entered into a relationship with Azriel, who he believed to be 18, when he was in his 40s. The government and the public may be outraged that defendant continued his relationship with Azriel after learning that she lied to him about her age, even though in the state of Illinois, the relationship was lawful. But the government is clearly attempting to artificially enhance the sentence by ignoring the true nature of defendant's relationship with Azriel. Put differently, if defendant had not traveled with Azriel to California on an isolated occasion a couple of months before Azriel's 18th birthday and had not video recorded the acts with Azriel, there would have been no racketeering acts to Azriel whatsoever. The government is free to feel moral outrage about defendant's relationship with Azriel, but it cannot enhance the sentence based on factors that ignores their own evidence. The government's fiction that defendant used cell phones to persuade, induce, or coerce or facilitate Azriel's travel should be rejected, since it ignores the nature of their relationship entirely, and the base offense level already punishes defendant for his conduct. Accordingly, a 2-level enhancement pursuant to 2G2.1B6 must be rejected. J. Racketeering Act 11, Forced Labor, Azriel. Base offense level 22, adjusted level offense 22. The government now finds it convenient to change its theory of prosecution to suit its sentencing arguments. The forced labor offense involves a base offense level of 22. As the government concedes, the heart of its forced labor count is the allegation that defendant obtained labor from Ariel, forcing or threatening force against her in connection with activities with other women and men, none of which occurred when she was. As argued in defendant's Rule 29 motion, there simply is no evidence, even from Ariel, that she was forced or threatened with physical harm to participate in the group activities. Her belated claim that she did not want to participate in such activities does not demonstrate that defendant forced her to engage in such activities, through physical harm or threats or physical harm. That said, if this court concludes that the evidence established that Ariel's participation in the group activities amounted to an offense of criminal abuse, the government's calculation and adjusted offense level of 36 would be accurate. But as stated above, the government did not establish that defendant committed an offense of criminal abuse in connection with Ariel's group activities with defendant and others, because the record is devoid of evidence of force in connection with those acts. K. Racketeering, Act 12, Mann Act violation, faith. Base offense level 14, adjusted offense level 14. Again, the government has no basis whatsoever to seek a 4-level enhancement for fraud based on defendant's failure to disclose his herpes diagnosis to Faith. As argued previously, fraud involves a false representation, scienter, reliance, and harm, Evans versus Atimo. And then she's basically making the same argument that she used when she was talking about Ariel's herpes case. So I'm not going to read this all over again. We'll skip down here. It says that the government's evidence does not show that defendant falsely represented anything to Faith or that Faith relied on any misrepresentation. Most importantly, there is no evidence of harm since Faith did not contract herpes from the defendant. Faith testified that after traveling to New York, she was diagnosed with herpes type 1 after getting cold sores on her mouth. Nearly 50% of the population has herpes type 1, cold sores. Even the government's expert would concede that herpes type 1 can be contracted from kissing. The record is devoid of evidence that Faith suffered any harm in connection with defendant's purported failure to disclose his herpes diagnosis to her. As such, a 4-level enhancement under a fraud theory, under fraud theory, oh, she said under a fraud theory, y'all, is nonsensical. 1. Racketeering Act 13, Forced Labor, Faith. Base offense level 22, adjusted offense 22. The forced labor offense involves a base offense level of 22. As argued in defendant's Rule 29 motion, there simply is no evidence, even from Faith, that she was forced or threatened with physical harm to provide oral to the defendant. Faith describes an episode in Los Angeles where defendant allegedly had a serious conversation with her and then directed her to give him oral. She does not describe defendant using any force or threatening any force. As a reminder, Faith never alleged that she was a victim forced to engage in any contact and denied that characterization of her relationship with the defendant. As such, defendant objects to the government's contention that this conduct involved criminal abuse and that a base offense level of 30 is appropriate pursuant to sentencing guidelines section 2A3.1. The government is off the chain. Get them, Jennifer, and hopefully, and Donnelly, act like you know, okay? Act like you got some sense when you impose sentencing. That said, if this court concludes that the evidence established an offense of criminal abuse, the government's calculation would be correct. M. Racketeering Act 14, Mann Act violation. Faith, base offense level 14, adjusted offense level 14. I'm getting there, y'all. We're almost done. For the reason argued in connection with Racketeering Act 12, no 4-level enhancement is justified under the government's novel fraud theory. N. Role enhancement. The government seeks a 4-level enhancement pursuant to Sentencing Guideline Section 3B1.1a on the basis that defendant was an organizer or leader of a criminal activity that involved 5 or more participants or was otherwise extensive. Defendant has argued extensively that the government failed to show the existence of an enterprise. The government's evidence showed that defendant was a famous entertainment who employed many people over the years. Defendant was unquestionably the boss of his employees, but the government falls short of establishing that he was a leader of criminal activity. Indeed, the government did not even attempt to prove criminal activity of the organization or other employees of the organization. A 4-level enhancement is simply not warranted here. O. Minor in custody, care, supervisory control of the defendant. Brazenly, the government seeks to enhance defendant's guidelines range under a theory that Azriel's parents entrusted the defendant to her supervision when she was younger, purportedly to assist her with her musical career, after which Azriel lived with the defendant. The record shows that Azriel's parents directed Azriel to lie to the defendant about her age and then encouraged her to seduce him in April 2015. The real-time text messages between Azriel and her mother revealed that Azriel's mother wanted defendant to promote Azriel's music career by commencing a romantic relationship with him. Again, the government seeks to sanitize the facts of the case, which show that after Azriel met defendant for the first time, she immediately began traveling with defendant and never returned home. Nothing in the record suggests that Azriel's parents objected to this relationship. The evidence shows quite the opposite. Indeed, Azriel's mother jokingly told her daughter weeks after Azriel met defendant that her son-in-law was going to be older than her. Azriel's mother certainly knew Azriel's age, even if the defendant did not, and should have said, "Girl, bring your ASS home right now." Not right now, but right now. Okay? So the record does not show that Azriel's parents entrusted defendant with Azriel's care, as much as Azriel was adamant that she wanted to live with defendant in Chicago, and Azriel's parents were eager to support her relationship with the defendant, presumably because they hoped financial riches would flow to them. It was defendant who sent Azriel home after Azriel disclosed her age. Regardless, Azriel was not a minor in the state of Illinois when she returned to Chicago shortly before her 18th birthday. As the government contends, as such, an enhancement under this theory cannot apply. P. Adjusted offense level. The following chart summarizes defendant's position regarding the offense level of each group account. Defendant contends that Racketeering Acts 5, 6, and 7 should be grouped pursuant to Sentencing Guidelines Section 3D1.2a, as should Racketeering Acts 9 and 10. Probation agrees. Racketeering Act 1, 12, Racketeering Act 2, 32, Racketeering Acts 5, 6, and 7, 32, Racketeering Act 8, 13, Racketeering Acts 9 and 10, counts 2, 3, 4, and 5, 32, Racketeering Act 11, 22, Racketeering Act 12, counts 6 and 7, 14, Racketeering Act 13, 22, Racketeering Act 14, counts 8 and 9, 14. Defendant contends that the combined offense level is 35. The offense level applicable to the group with the highest offense level is 32. Pursuant to Sentencing Guidelines Section 3D 1.4, the number of units that the remaining groups represent, the offense level should be increased by 3 levels, 3 units, for a total of 35. Because defendant's criminal history score is 1, the guideline range properly calculated is 168 to 210 months. Conclusion: for the foregoing reason, defendant's sentencing range is 168 to 210 months, and we calculated that to be, what did we calculate it to be? Okay, let me pull back, open the calculator. Did we say, let's see, 168 divided by 12 is 14. So 14 to 17 years, I think, is what we came up with before. And so that is what she is stating, and that's respectfully submitted, Jennifer Bonjean. So what do you guys think? Does it seem accurate to you? Do you think 14 to 17 years is fair? Do you think Ann Dunley is going to pay the least bit of attention to this? It is going to be interesting. I think it should be 3 years time served, and then she go and appeal this to the Second Circuit, and it get overturned, and he comes home. That's my story. That's my answer, and I am sticking to it. So guys, that's it for me. Go ahead, hop down in the comments and let me know what you think. Rate the video and subscribe to the channel if you haven't done so already. And until the next time, I shall talk to you guys later. Bye-bye.